Good evening, Commissioners, and thank you for the opportunity to speak with you. My name is Dr. Lomax. I'm from Jackson County, and it's a privilege to be with you here this evening, addressing the same issue that has been addressed here concerning Citizens United. First of all, I would like you to know that I am not anti-corporation. In fact, I have two corporations, and they are excellent entities for conducting the business for which they were chartered. These charters allow them to enter into contract, sue and be sued, and through human effort perform all necessary business functions. When corporations act in accord with granted and earned privilege, rather than on the basis of inalienable rights, they benefit not only business, but also the enterprises of our communities for which they serve. Today we live in a two-tiered nation. On one hand, we have the backbone of industry and job creation, which is our Main Street businesses, and the upper tier, which is composed of mammoth transnational monstrosities that have no patriotism, no communal interest, and no national allegiance. With their overwhelming wealth and the power it brings them, they control our government bodies, making laws and enforcing regulations that we must abide by, but from which they are exempted. An example of this two-tiered system is the TARP bailout and the Consumer Protection Agency that sprang from the debacle of the 2008 economic meltdown. Though our local banking institutions that engage in standard acceptable banking practices receive not one penny of TARP funds, they carry the heaviest burden of these regulations. In a recent meeting with a Macon bank official, we were shown a 3-inch regulation manual known as Frank Dodd Act. This banking official indicated the burden of regulation is becoming so heavy that the well-being of the bank is being seriously challenged. While our local banks labor under these massive regulatory burdens, the too big to fail banks responsible for the meltdown go on unimpeded, doing pretty much what they were doing before the meltdown, investing in risky and convoluted derivatives, overseas investments, and yes, taking the TARP funds that we the taxpayers supplied them and approved as a means for capital investment on Main Street, and taking those funds to buy up other institutions. Unbelievably, the major 5 too big to fail banks are even bigger today in 2012 than they were in 2008. And all of those banks bought out those other banks with the funds that we supplied them through TARP. It is such common practice today for transnational corporations to run roughshod over our local interests that we have come to be complacent in acceptance of the fact that this is good for capitalism. In the colonial days before the birth of our nation, the situation was not much different. The British Crown deliberately empowered corporations to plunder colonial resources and gave them privilege and power far beyond that of the colonists. We all remember the Boston Tea Party. What we often do not realize is that this was a revolt not just against the Crown and taxation without representation, but it was just as much so a revolt against a corporation, the East Indies Trading Company, that held a Crown-granted monopoly while being largely relieved of the burden of taxation. If this situation sounds familiar, it should, because this is not a whole lot different than what we see today, as I would expect that almost every adult individual in this room paid more in taxes in 2010 than General Electric did. In 1776, things did change for the Americans. The American revolutionists rose against the Crown and the corporations to bring into being a new nation free of these oppressive forces. For good reason, our Constitution does not mention corporations, and our Bill of Rights, protecting our inalienable rights, grants no such rights to corporations. Throughout the decades following the Revolution, court rulings, not legislation, began eroding the freedom from corporate tyranny for which our forebears fought and died. In 1886, 110 years after the signing of the Declaration of Independence, the unelected and appointed for life Supreme Court justices first sanctioned corporate personhood. So for 110 years, our nation survived and thrived without corporate personhood. This was in the case called Santa Clara County versus Southern Pacific Railroad. Ever since, corporate, artificial, non-human entities have used the court-sanctioned personhood doctrine to gain more and more rights while eroding our human inalienable rights. Citizens United versus Federal Election Commission ruling in 2010, just one in a long series of rulings relying upon the false notion of corporate personhood, grants freedom of speech, rights to corporations that should be reserved for the voice of we the people. The early American experience demonstrates that corporations can thrive without personhood and capitalism can flourish. We do not have to live under corporate tyranny. We can free our governments from the shackles of corporate rule, and it is time for a new revolution. I call upon you as Macon County Commissioners to follow the lead of the Board of Aldermen of the town of Franklin in passage of the same resolution, stating that money is not speech and humans, not corporations, are persons. Thank you.
Thank you, Dr. Lomax. That was all we had for